The Factories Act, 1948, Act No. 63 of 1948, Chapter 10, Penalties and Procedure. 95. Penalty for obstructing inspector. Whoever willfully obstructs an inspector in the exercise of any power conferred on him by or under this act, or fails to produce on demand by an inspector any registers or other documents in his custody kept in pursuance of this act or of any rules made thereunder, or conceals or prevents any worker in a factory from appearing before or being examined by an inspector, shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 10,000 rupees or with both. 96. Penalty for wrongfully disclosing results of analysis under Section 91. Whoever, except in so far as it may be necessary for the purposes of a prosecution for any offense punishable under this act, publishes or discloses to any person the results of an analysis made under Section 91, shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 10,000 rupees or with both. 96a. Penalty for contravention of the provisions of sections 41b, 41c and 41h1. Whoever fails to comply with or contravenes any of the provisions of section 41b, 41c or 41h or the rules made thereunder, shall, in respect of such failure or contravention, be punishable with imprisonment for a term which may extend to 7 years and with fine which may extend to 2 lakh rupees, and in case the failure or contravention continues, with additional fine which may extend to 5,000 rupees for every day during which such failure or contravention continues after the conviction for the first such failure or contravention. 2. If the failure or contravention referred to in subsection 1 continues beyond a period of 1 year after the date of conviction, the offender shall be punishable with imprisonment for a term which may extend to 10 years. 97. Offenses by workers. 1. Subject to the provisions of Section 111, if any worker employed in a factory contravenes any provision of this act or any rules or orders made thereunder, imposing any duty or liability on workers, he shall be punishable with fine which may extend to 500 rupees. 2. Where a worker is convicted of an offense punishable under subsection 1, the occupier or manager of the factory shall not be deemed to be guilty of an offense in respect of that contravention, unless it is proved that he failed to take all reasonable measures for its prevention. 98. Penalty for using false certificate of fitness. Whoever knowingly uses or attempts to use as a certificate of fitness granted to himself under Section 70 a certificate granted to another person under that section, or who, having procured such a certificate, knowingly allows it to be used, or an attempt to use it to be made, by another person, shall be punishable with imprisonment for a term which may extend to 2 months or with fine which may extend to 1,000 rupees or with both. 99. Penalty for permitting double employment of child. If a child works in a factory on any day on which he has already been working in another factory, the parent or guardian of the child or the person having custody of or control over him or obtaining any direct benefit from his wages shall be punishable with fine which may extend to 1,000 rupees unless it appears to the court that the child so worked without the consent or connivance of such parent, guardian or person. 100. Determination of occupier in certain cases. Rep. by the Factories Amendment Act, 1987, 20 of 1987, S. 38, W.E.F. 112 1987. 101. Exemption of occupier or manager from liability in certain cases. Where the occupier or manager of a factory is charged with an offense punishable under this act, he shall be entitled, upon complaint duly made by him and on giving to the prosecutor not less than 3 clear days' notice in writing of his intention so to do, to have any other person whom he charges as the actual offender brought before the court at time appointed for hearing the charge. And if, after the commission of the offense has been proved, the occupier or manager of the factory, as the case may be, proves to the satisfaction of the court, A. that he has used due diligence to enforce the execution of this act, and B. that the said other person committed the offense in question without his knowledge, consent or connivance, that other person shall be convicted of the offense and shall be liable to the like punishment as if he were the occupier or manager of the factory, and the occupier or manager, as the case may be, shall be discharged from any liability under this act in respect of such offense, provided that in seeking to prove as aforesaid, the occupier or manager of the factory, as the case may be examined on oath, and his evidence and that of any witness whom he calls in his support shall be subject to cross-examination on behalf of the person he charges as the actual offender and by the prosecutor. Provided further that if the person charged as the actual offender by the occupier or manager cannot be brought before the court at the time appointed for hearing the charge, the court shall adjourn the hearing from time to time for a period not exceeding 3 months, and if by the end of the said period the person charged as the actual offenders cannot still be brought before the court shall proceed to hear the charge against the occupier or manager and shall, if the offense be proved, convict the occupier or manager.